Uh, as usual, I would like to ask you that if any of you have any questions, please ask that immediately. Maybe I will ask you to let me finish one sentence, but then I will listen to you. Probably I will not be seeing any hands raised, so I don't mind if you just um, start talking and I won't get any bad feelings about it. Don't worry. So just ask your questions. I'm very happy to answer them. And before I start, I think quite some of you were present on my summer presentation on the two directives, which should have been taken over by Hungary and all other member states by early August. In case of Hungary, this did not happen. This still not happened. It will probably happen by the 1st of January, when the parliament accepts the draft law I will talk about right now. This draft law was issued to the parliament about 1.5 weeks ago. And when I read the final text of this draft law, I was pretty surprised because I knew previous texts and quite a lot of provisions were deleted from it. Also important and important provisions that would have been very useful, for example, in connection with concluding a collective agreement at the company. And also other provisions which could make things more clearer. For example, how can a worker take up a second job? So all these provisions from previous drafts were deleted, and now I'm a bit surprised that quite a smaller number of provisions will be amended in the labor code than before, but still, I have to say this was the most significant amendment, or this is the most significant amendment of the labor code for at least 5 years. And shortly I will tell you why. I will also plan to talk about at the end of the presentation 3 topics which might be pretty relevant in our days. The first one is an update on this saga on the daily and weekly rest. I was talking about this, I think last year, about the 2020 decision of the Hungarian Constitutional Court. Now, as a consequence of this decision of the European Union, justice is also to be expected. So the Hungarian Constitutional Court caused even more trouble than we first thought it has. We will talk about this later. And also because of the huge inflation rates in forint, this evergreen topic of remuneration in foreign currency came up again. So I will also talk about that. And also, at least in the last year's evergreen topic, telework from abroad, I think I should also talk about this topic. Okay, let's start. So I will not talk about the directive because I did so in the summer. Just some quick reminder, there were 2 directives to be taken over. The first one is this 1152 directive on transparent and predictable working conditions. And I think this is a quite important directive with respect to working time issues. And I'm talking about this now because the Hungarian legislator did not take over such rules. So if you remember, there are two types of work schedule according to the text of the directive. The one is predictable or mostly predictable, and the second one is non-predictable or less predictable. And actually, there's no definition. What do they mean? The Commission gave out a paper to the member states according to which more predictable means that the worker knows at least 50% or can predict at least 50% of his or her work schedule. And as a consequence, less predictable or non-predictable is where he or she does not know, cannot predict his or her work schedule in at least 50%. But actually, there are several issues with this. Firstly, the Commission, the European Commission, has no right to interpret European law. It's the sole right of the European Court of Justice. So actually, it's not important what the European Commission is saying. The second one, I think, is even more important. The Commission did not say what predictable means. So then we can cannot really tell what is 50% predictable if we do not know what predictable is. Like, is it predictable if I know my work schedule 2 days ahead? Or does it have to be 7 days ahead or 2 weeks ahead, or what does it mean? Nobody has thought about this. And reading the text of the directive, I have serious doubts whether the Commission was right and the Hungarian government was right about not dealing with this issue. But I'm not going to talk about this in details because I think it's a very far away risk for companies not owned by the state. It can be an issue that, for example, let me tell you an example where it might matter. You are a factory and you order extraordinary working time for the weekend, let's say for Saturday, and the worker was traveling like 2 hours to the factory, and there at the factory gate he or she gets to know that his extraordinary work is not needed. It's a typical issue. And the directive says that in this case, the worker should be compensated. The Hungarian law, as I said, has the opinion that this provision is not to be applied in Hungary because in Hungary all workers' work schedule are at least overwhelmingly or even totally predictable. But I have some doubts here, but since I do not see big risks here unless you are a state-owned company, I will not talk about this in details. The second directive is the Work-Life Balance Directive. This one was more or less taken over correctly by the Hungarian legislator, I guess. We will see all the details. And then let's already go to the first provision of the Labor Code, which was amended. And I think we already start with the merits. So I think this is the most important change in the Labor Code. It is about the prohibition. It is about the principle of prohibition of abuse of rights. This sounds very high level, but you will understand in a few minutes that no, this is a very important and very basic issue. At least it will be from January on. What is this what does this principle says? This principle says that in case the employer on the surface keeps all the laws and is in line with all the legal provisions, but uses its rights in order to misuse its power or to hurt other people's rights, then even though on the surface the employer acts lawfully, it will be unlawful. Let me tell you an example. There's a layoff at the company, and from 100 people, you have to lay off 20. And the leader of the employer chooses those employees who are somehow troublemakers, like asking too many questions or had some conflicts with such leader and so on. And then formally, this is a layoff, but in reality, this is somehow a revenge against those workers. And let's be honest, it does happen quite often. But also, let's be honest, if you have to lay off 20 people from 100, you will always choose the problem ones. You will always choose those with bad performance. You will always choose the troublemakers. You will always choose, let's be frank, those ones you simply don't like. And this has always been like that. Since I was dealing with labor law for 25 years, this has always been like that. And now, what should we do as employers? How does it work, a layoff? In my experience, you just collect the name of those who you think the company can be okay without. And in most of the cases, this is usually quite a subjective list. Based on the reasons I told you, it might be only performance issues, but it might be also personal issues on the basis of which you choose who to lay off. And from January on, in case you, let's say, lay off someone, just as an example, this employee might insist that you acted in breach of the principle of prohibition of abuse of rights. And then you have to prove that no, you didn't. So the logic is pretty much the same as in case of discrimination. Only in the case of discrimination, I think most employers have the knowledge, also have the attitude to avoid discrimination charges, like you don't keep the employees with blonde hair and the blue eyes. It's common sense. But in this case, in case of prohibition of abuse of rights, it's much harder for you to prove that you kept this piece of law. And I myself, as a labor lawyer, have serious doubts on how to act in such a court case, or what to prove in such a court case. I only have one very simple and very general idea, which probably most of you will don't like, but I'm sorry, I don't have any better idea right now. Before you start any terminations, let it be layoff or termination based on performance or whatever type of termination, I have to say also including the ones which do not need justifications, like termination during probation period or termination of an executive employee or termination of elderly workers who are already pensioners. So before you do anything like that, you have to have reasoning which shows that no, that you kept the prohibition of kept the provisions on prohibition of abuse of rights. And I think the best way to do this is to have some point of view of objective reasons. Like you have some decision written previously that you will lay off the ones who has the worst performance, or you will lay off the ones who had some issues with their behavior, or you will lay off the ones who you will do your layoffs based on social issues, like you will keep the employees who are who need the job and the money, and who are coming from a richer family, you will lay off. Something like this you will have to have. Of course, especially the last one I told might have some other legal implications, for example, data protection implication. But I think it's a good idea to have some previous plan and some principles on how the layoff shall be done in the future. If you don't have it, because of these rules I'm was just talking about, so the burden of proof will be on the employer from January on, that no, you did not breach the violation, the provisions on the prohibition of abuse of rights. It will be very hard for you, and you might easily lose the court case. And there's also one more serious consequence of this. If the court holds that you breached this principle of prohibition of abuse of rights, the court will reinstate the employment. So it's not only 12 months absence fee as in a normal case, which is your risk. You might even pay up to, I don't know, 3 years of salary if the court case is going on for 3 years, and at the end you have to take back the employee. So I think this is the most important ones, and you really have to think over all the terminations in a much proper way than you did until now, because the legal risk will be much higher, and I think the employees lawyers will practically always come up with this, that you breached this provision and you did not act in good faith. And I also have some practical proposal for you. If you already have some names you want to dismiss, probably it's advisable to do this now until the end of the year. Of course, be aware of the collective redundancy rules, but otherwise, terminating a person this year will be much, or is much easier than it will be next year. The second amendment is not a real amendment. It was already court practice for a long time, but now it's already in the law. In case of probationary period, it's enough to mail the letter of termination on the last day of a probationary period. It's also nothing new here, but just to remind you, if a probationary period starts on 1st of January, remember it does not end on 1st of April, but on the 31st of March. So you do not count it as a deadline. It is actually a 3-month period based on court practice, but there are risks here, especially because, in my opinion, this general court practice, which is also reaffirmed by the Supreme Court, that the probationary period is a period and not a deadline, is questionable. And if because of the text of the law, I don't want to go into details, but if this general practice will be attacked successfully by any lawyers, then you might be late for the deadline of giving this letter. But again, probably it's a small risk, because almost all courts will tell you that the probationary period is not a deadline, it's a period. So you can send this letter on the last day of the probationary period. Sorry, I made the mistake. I mixed up two things. This is new. This was not court practice until now, that you can send a letter. You had to give it over. You had to serve the letter to the employee until now. What I mixed it up is that also there's a new provision in the law that in case of extraordinary termination, you can send a letter on the last day of the deadline, and this hasn't changed. Sorry for the mistake. So this is new here. On the probationary period, in case of a probationary period, you have to, it's enough if you send the letter of termination on the last day of the probationary period. So this is new, sorry. Now, we talked about this a lot in the summer, that the information letter, the content of the information letter is way more than it was before. You have to inform the employee on a much more issues than until now, than until the end of the year. And I have to say that the Hungarian legislator took this provision over in a quite employer-friendly way. So sometimes these issues included in the directive are much longer than what is in the labor code. Of course, you have to keep the rules of the labor code as a general rule. So it's quite good news for the employers, actually. And there are also some other good news I will tell you later in connection with this. But still, let's look at some of the points here. Point A, B, and D are unchanged. Task of jobs means job description. The place of work has to be in the informational letter, but only if it's not in the work contract. So if it's in the work contract, you don't have to do anything about it. If it's not in the work contract, then the information letter should be changed with this. Then I think point E is new and important. You have to give way more information on working time than you had to give until now. You can see that you have to give information on the working time schedule, possible start times of the working time, daily working time, duration of extraordinary working time, and also on the specific nature on the employer's activities. We talk about here multiple shift or work of non-stoppable nature or seasonal work, things like this. You have to inform the employee on all these issues. It's pretty new. Then F is unchanged. G is also unchanged. H is more or less unchanged, I think. And then Y also, but J is totally new. Employer's training policy. Length of time employee may spend in training. Actually, I don't know what training policy means, but if you look at the directive, you only have to inform the employee on the possible trainings he or she can be present at. So I think that's what the legislator meant under training policy. In case of K, you only have to write the tax authority, so NAV. That's it. And L is unchanged. You already had to inform the employee on this. Now, I think this is the most important issue which everyone is interested at. Whether you have to give a new information sheet to all employees. And I have good news. The legislator decided not to. So in case of existing employments, you do not have to give a new information sheet for everybody, except there's an exception. Anyone who requests it for 3 months after the new law enters into force, so practically until March 31st, you have to give to such employees a new information sheet. So if you receive a request from such employees, you have to give the information sheet. Otherwise, you have to give the new information sheet for new employees who enter the company after the 1st of January. But actually, I have some doubts here again. First, there's no such provision in the EU law. It just says that the employees has to be given this and this type of information sheet, and it doesn't say that all the employees do not have to receive this. And also, I think it would, let's just imagine it's like 2026, and then you look at your HR documentation and see that some employees have different info sheet than others, so it looks a bit awkward. So I think even if you are not obliged to give a new type information sheet with time, even if not in January but with time, sometime next year, I think it would be a good idea. But I cannot say it's a legal obligation. So if you don't have the time to deal with this, you don't have to do this. Okay, there's also good news that in case something is in the work contract, for example, length of working time or place of work, then on this topic you do not have to give information, so it should not be included or does not have to be included in the information sheet. And also some parts you see from E to Y, we can go back. Duration of working time, remuneration, vacation days, and termination may be referred to by a provision of the law. I also have some bad news. If there is a change in the content of the information letter, you have to give it immediately. And sorry, I forgot to tell something, also some other bad news. From January on, it's very important. You see the deadline will not be 15 days, it will be 7 days only. So it's not a big issue, by the way, because usually employers give this information letter together with the work contract. But still, if you miss that, you will only have 7 days and not 15 days in case of new entering employees. In case of old employees whose information letter is to be changed, you have to give this immediately when the change takes effect. Just remember this, it's a pretty new and I think it will give you a lot of task for the HR. So for example, if there is no place of work in the work contract and the employee will have a new place of work, you have to give this information in writing on the day when he or she will have a new place of work. There's also a second information sheet which a lot of people do not even know it exists. It's about information sheet for abroad. It already exists in the present text of the labor code. So if your employee is sent to abroad to work abroad for more than 15 days, you have to give the employee a special type of information sheet. And I'm not going into details here because probably it will not be interesting to many of you, but remember that this information, the content of this information sheet will also be much broader. And in case of any work abroad which exceeds 15 days, you have to give this to the employee. One point I need to mention here. I think one of the last times I was talking about the posting directive too. Just shortly, if you don't remember, this directive prescribes that in case let's say a Hungarian company provides services in another EU country, or in case Hungarian company sends its employees to it's a sister or mother company abroad to the EU. Or there's also a third case in case a Hungarian temporary agency company sends its employees abroad to another EU country, then with some quite important respect, especially wage, not the Hungarian law, but the law of the host country is to be applied. So if you provide some services, let's say you build a house in Germany, then the workers working on this project in Germany should be paid not the Hungarian wage, but the German wage. And under German wage, I don't mean the German minimum wage, but the wage which should be paid on that particular geographical area and in that particular industry. So let's say if it's a carpenter, then you have to look, and this carpenter works in Munich, then you have to look at if there's a collective agreement which geographical scope is Munich or Bavaria, and its social effect is for carpenters. And if it's and if there's such a collective agreement which applies to all employees in Bavaria, then I mean who employ carpenters, then you have to pay this wage, also including other wage supplements. So if there's a night supplement or an overtime supplement, you have to pay that too. And why is it important? Because in theory, at least, member states have to give information on such provisions, and they have to keep up a homepage giving such information. And in the information letter, you have to give information on such homepage so that the employee may check whether you keep all the posting rules. By the way, I have very bad experiences with such homepages. In quite some cases, such homepages are in the home language of the country. For example, I remember the Romanian homepages in Romanian, so not in English, not in Hungarian. It's only in Romanian. Also Greece's homepage is like that. That's the first issue. The second issue is that I have doubts but whether all significant informations are to be found on this homepage. So I'm not totally sure whether on the German homepage you will find what is the collective agreement rate for carpenters working in Munich. So probably if you have such a case that you post someone to the EU, probably it's wiser to talk to a local lawyer. So in our case, a German lawyer from Munich, let's say. Okay. There's a long provision in the Labour Code. I think this point L is the last one, which already exists and says when the employee is exempted from work. So when the employee does not have to work during working time. And because of a directive provision which was taken over, we have a new point here, this point L, which says that in case the employee has a relative or somebody who is living in the same household as the employee, and this person needs care for serious health reasons, the employee may be exempted from work up to 5 working days in a year. Remember that there's a very similar provision already existing in the Hungarian Labour Code for at least 15, 20 years, which says that the employee has a right for unpaid leave, in case a similar case that the relative needs home care. But this is something different. It's not unpaid leave. This is just an exemption from being present at work. And this exemption shall be granted in no more than 2 parts. And the doctor of the person who needs home care will have a certification on this. Now there's also a new provision, and I think it's probably more important than the previous one, that the employee may request the amendment of the work contract, except for the first 6 months of the employment. Any employee may do this. Now, what is this paragraph 1 it refers to? It's already in the labor code, so this is not new. Section 2, which I was talking about, is new, that the employer has an obligation to inform employees on the possibility of full-time or part-time employment, telework, or indefinite employment, of course, the latter in case of fixed-term employment. Now let's talk about this. This has already been part of the labor code for some years, but quite frankly, just among us, I have not seen any employer giving such information. It's totally a provision without a sanction, without a legal consequence if you do not do this. But in theory, you have such an obligation. And let's go back. If you give such an information to the employee, unless he or she is not working for 6 months at you, may request the amendment of the employment contract. Now let's continue. So you see, this is based on the employer's information, and basically any employees may have such a request unless they don't work for you for 6 months. And there's another provision where no information by the employer is needed. So this modification can be requested by the employee without an information of the employer. But there are some further conditions. It's only possible until the child of the employee reaches the age of 8, or an employee providing care. And of course, again, except during the first 6 months of the employment. And the subjects in which the employee may request the change is a little different from this. You see, the first one was full-time, part-time, telework, and indefinite employment. This says change in the place of work. This is new. This is not included in the first group of cases. Change in his or her work schedule. This is also new. Telework and part-time, this was already in the previous group of cases. So any employees whose child is below 8 may request this. And now listen, this is the most important part. Whether this request by the employee on changing the employment contract is based on paragraph 2 or paragraph 4, So this is paragraph 2 here. No, sorry, this is paragraph 2 here, and it can be based on this. And this is paragraph 4. The employee has to give such request in writing, and in this request he or she also has to include the requested date of change, and the employer has to respond to this request within 15 days. And 3 scenarios might happen. You might accept the employee's request, and then the work contract is modified. You might reject the request. In this case, you have to give reasoning for the rejection, just like in the case of a termination. So you have to tell the employee in writing why you do not accept the request on modifying the work contract. And the employee may go to court against such reasoning. And in case the court holds that the reasoning was unlawful, you did not give for example, a reasonable reason to reject the employee's request, because I don't know, the employees say that there are a lot of people who are working on part-time, and it's not reasonable that you rejected the employee's request. Then the court will modify the work contract instead of the parties. Of course, there's a lot of questions here also for me as a labor lawyer, so it's pretty unclear for me now what could be a good reason for rejection, or in what cases the employee might might win such a court case. But I think probably the employer will really have to show the reasons why it cannot accept the employee's request. For example, there's an order by the owner that they cannot employ part-time people, something like this. And of course, there's also a second question, whether this explanation will be accepted by the court, because sometimes such explanations that the owner said this and that will not be accepted. For example, in case of collective redundancy, this is even in the EU law. So there are a lot of open questions here, and of course I'm not able to answer all these questions at the moment. We will see what the court practice will be in a few years. But be aware that you have to give an answer, and this answer have to include a reasoning. Because what if you don't do this, and this is scenario 3, if you do not answer to the employee's request at all, then the employee might go to court again, and he will win the case because you missed this 15 days deadline. So what is the nightmare scenario for you guys here? You receive such a request, you do not care about this, you do not answer. Then the employee goes to court, and the court will say, okay, the employer did not answer within 15 days. So the court will modify the work contract. So try to avoid this scenario, and please remember that if you receive any such request, answer it, and the answer should include a reasoning. And there's one more bad news. In case the employee is terminated on a basis of a termination which does not require reasoning, and there are quite some of them. For example, probational period, for example, executive employees, for example, pensioners. In this case, but also if you terminate the employment of a fixed-term worker prematurely. So all in these cases, the employee may request that he thinks that the real reason of termination was in connection of one of these cases, so A, B, C, D, and E. Let's say that the employee requested this working time exemption we were talking about under point L, or we have not talked about parental leave or paternity leave, we will talk about this later. And the employee may request that he or she thinks that you were in breach of the principle of acting in good faith, which I was talking about in the beginning of the presentation. And even though you were not obliged to have to include a reasoning in your termination, you are not obliged to tell why the employment is terminated. If the employee thinks that you terminated the employment because he or she was requesting one of these leaves, then you have to provide a reasoning. And this is the most important thing. Imagine until now, in case of a probational period termination, you did not have to give any reasoning. The only thing you have to take care of is keeping the discrimination rules. So if the employee was in the first months of pregnancy at the beginning of the employment, and at the end of the probationary period, it was obvious already that she was pregnant, then some employers terminated the employment on the basis of under the rules of probation period, and of course this was against this discrimination rules. It was obvious that the real reason for termination was the pregnancy of the employee, but these were very rare cases, and just quite among us, I think a normal employer would not do this. But any employer until now, until the end of 2022, would just simply terminate an employee who they are not happy with for any reasons, with immediate effect during probationary period. But from now on, from January on, for all these cases, probationary period, executive employees, pensioners, you have to have a reasoning in the drawer. You do not have to give it to the employee. You do not have to write it in, include it in the termination letter. But if the employee requests it, then you have to give a reasoning. And it's among us, it will make things much harder, because it will mean that practically all terminations will have to have a reasoning, either included in the termination letter or not included, but to save it for bad times when the employee comes up with such a request. And this request of the employee can come up within 15 days. So it's important that there's a condition that the termination documentation does not contain a reasoning, because it does not have to. Then the employee has 15 days to come up with a request that he or she thinks that the real reason is based on one of these. And if the employee requests to have a reasoning within 15 days, then within another 15 days, you have to provide the employee with a reasoning. And again, if you miss this deadline, then the court case is already lost. There's one question here which I don't know the answer to, but it came up in my mind. What if the employee is obviously not serious? Like, let's say this is an employee without a child, and he writes that he requested paternity leave. Let's say this. It's a very good question, and of course the courts will decide on this, but I think even in this case, I would keep these rules. Like, you could say that you are not serious because you don't have a child and so on in the reasoning. But if you don't keep up with these rules and you don't give an official reasoning to the employee, you can easily lose the court case, even in this case, even if the employee is not serious at all. There's also one more question here. Whether you have to inform the employee on this possibility in the termination letter. Formally, there's no such request in the labor code, but there's a provision according to which the employer is obliged to give all information necessary to the employee. I don't know whether this provision will be interpreted in a way that the employee should be informed on the possibility of requesting a reasoning. We'll see what the court case will be. Discuss this issue with your lawyer. I would say probably I would include it, although it has some obvious risk if you do so. Also, the cases where ordinary termination cannot be provided to the employee, so this will be unlawful, became longer. So you see that this infamous point L we talked about, this personal care, will be also one period where you cannot serve a termination letter to the employee, otherwise it will be lawful right away. Then another bad news, I think I already mentioned this point AB. You see that it will be a replacement case if the employer is in breach of the principle of prohibition of abuse of rights. I talked about this at the beginning quite a lot. Just remember that it's if you breach this provision, it will not be just a simple unlawful termination, but the consequences will be even harder, because you have to take back the employee and pay a lot of money to him or her. Okay, let's go to working time provisions. If you employ reference periods, so munkaidőkeret in Hungarian, then until now you only had to inform the employee on the start and end dates of such reference period. From now on, you have to include the number of hours of this reference period. So if it's a February reference period, that's 20 days of working days, 20 times 8, which is the working hours per day, it will be 160. So in this example, you have to write 160 hours. Another piece of paper should be given to the employee, just to keep HR admin people busy, is the rules of allocation of working hours. So it's called work schedule, and the employees should be informed thereon in time, which means before they start working based on such work schedule. Now this is a very hot topic, and I will talk about it more at the end of the presentation, but I think with regarding the problem itself, I think I should make some notes here. I don't know if you remember, but I was talking about probably last year on this questionable decision of the Hungarian Constitutional Court from May 2020, when the Constitutional Court said that based on Hungary's constitution, the daily working time and the daily rest time and the weekly rest time need to be given out to the employee separately. And if you remember, if you take this seriously, and you take an example of a classical work schedule of 5+2, where Monday to Friday will be working days and Saturday and Sundays will be rest days, then this would look as following. Saturday and Sunday as 2 calendar days will be rest days, which means that the first rest day, Saturday, will start at 0 o'clock on Saturday morning or Saturday dawn, and will finish at 24 hours later at 0 o'clock Sunday. Then Sunday, it's the same. It will end at 25 o'clock on Sunday evening. And during this period, during these 2 calendar days, you are not allowed to allocate a daily rest period, which should be 11 hours. So what can you do? Either you give it out before the 2 rest days, which means that this 11 hours should end at 24 o'clock on Friday, which of course means it has to start at 13 o'clock, so 1 p.m. So the employee has to stop working on Friday at 1 p.m. And if the employee works 8 hours a day, plus there's a 20 minutes lunch break, then you can count that the employee has to start at 4:40 a.m. on Friday. It's a very livable work schedule, I guess. Or the other way, if you allocate this 11-hour daily rest after the 2 rest days, then the employee cannot start before 11 a.m. on Monday. It sounds a little better, but it's still not ideal. So you see that the decision of the Constitutional Court is obviously has obviously not considered the traditions of how people work, not only in Hungary but also in the world elsewhere, and it can cause quite a lot of problems in the future. And frankly, I think the only good solution would be, based on European Union Law 2, is if you want to keep this 5+2 work schedule, is to minimize the length of weekly rest, because now it's 2 days or 48 hours based on Hungarian law, and but the European Union Directive on Working Time requests only 24 hours plus 11 hours of daily rest. So it's 35 hours altogether. And I think the ideal solution would be if we would de facto keep this 5+2 system, but in a way that on the weekend there would be a 24 plus 11 hours rest, during which the employee is not allowed to work. Let's say it should be Sunday and plus Saturday evening, and the rest of the Saturday, so until early afternoon or on Saturday, it should be some, I don't know, special weekend time or something like this, where the employee might have overtime. Because of course there's also another issue I haven't mentioned here, that the Working Time Directive does not differentiate between normal working time and extraordinary working time, and it only says there's working time, and it also says there's a rest period, and rest period is something which is not working time. So there's also another issue here, that Hungary is in breach of this too, because we have this so-called overtime on rest day, which is a quite surreal thing if you read the European Union Directive on working time, because it's either rest day or it's either working time. It cannot be both at the same time. So this solution would solve the problems caused by the Constitutional Court, and this would also be in line with the Working Time Directive. However, the legislator did not go this way. It chose another way, that it says that if you allocate weekly rest, you do not have to allocate daily rest. This is what the legislators thought would be a good idea. We will see at the end that it's not a good idea. So it's this baby is born dead. Unfortunately, it will not solve the problem. But for the time being, this is the way the legislator tries to solve this issue, this problem caused by the Hungarian Constitutional Court. And for 1 or 2 years, until there will be further troubles, I will talk about this later. This is the rule you have to keep up with. So, and I think if you don't look at European Union law, only Hungarian law, this might be a solution, but only based on Hungarian law, that you just do not allocate daily rest. If you allocate weekly rest, and if there's no extraordinary working time performed during the weekly rest, then, which is, by the way, as I said, based on European Union law, is a nonsense anyway. So in this case, problem is solved, but only based on Hungarian law. And at the end of the presentation, we come back to this issue. I did not want to go into details with this because there are quite complicated rules, and we could talk about a half an hour only on this provision. But I just want to make your attention to the fact that until now, if the law says that in case the job is under health hazard, then there are stricter provisions. For example, night work cannot exceed 8 hours. But from now on, it's not only the job, but also the employee. So if the employee has health issues, and based on these health issues, the work is dangerous for him or her, so there's a health hazard, then these restrictions will apply. So it means that before you make a work schedule for any employees, you have to consult the company doctor too. It's again some pretty hard administration stuff from the 1st of January. Now, the whole press is talking about this as this would be something totally new, the so-called paternity leave, but actually it's only a little new. So even until now, we had 5 days of paternity leave in the labor code. Now these 5 days became 10, so it's now 10 days of paternity leave. And there's also some good news that until now the 5 days paternity leave was reimbursed by the state to the employer, and this remains. So out of the 10 paternity leave days, 5 will be paid by the state continuously as until now. But the bad news is that the other 5 has to be paid by the employer. There's also a good news in this bad news that for the second 5 days, only 40% of the absence fees to be paid to the employee. But this 40% is paid totally by the employer. There's also a second new entitlement for the worker, and if you read it for the first time, this might look shocking, but don't worry, it's in the reality, it's nothing really dangerous for the employers. It says there's 44 working days, so it's practically 2 months of parental leave until the child's age of 3 years. It sounds pretty much, but if you keep on reading, this entitlement is firstly paid only at 10% absentee fee. That's the first good news. So it's almost a payless entitlement. And secondly, this is up till the child's 3 years of age. And under Hungarian law, this 3 years of age is the same period when the employee is entitled to unpaid leave. Of course, most of them will return when the child is 2 years old, because the social security remuneration is pretty low between the second and the third year of the child. But it practically means that those parents who return for money will not decide for this, because they will need the money. They will not 10% of the absentee fee will not be enough for this. And those who decide to stay at home, then of course they will not take this. So I would say that a very low number of parents will use this opportunity, but in theory they might use this, that they have 2 months until the child's 3 years. Of course, these 2 months, these 44 working days, is a one-time opportunity. So it's not per annum, it's for the whole period of 3 years. Also some mediocre bad news for the employers. If based on economic reasons you recall someone from vacation, then you have an obligation to provide reasons in writing, which means that if you act like this, like someone is on holiday and you request this person to come back to work because, I don't know, there's a huge need for workforce, then you have to write him an official reasoning that the reason why I'm calling you back is because I cannot cope without your workforce, or something like this, because we have some new orders or something like this. And of course, the employee might go to court against this, but quite frankly, I don't think there will be much court cases like this, because the employee will terminate their employment if they don't like the way they are treated first. But in theory, there might be such court cases too. By the way, I'm asking you, do you think from an employee's, not an employer's, from an employee's point of view, what is the best thing an employee can do if he or she is on holiday and does not want to be called in? What do you think?
Switch off the phone.
Very good. Yes, nobody is obliged to answer phone calls while on holiday. Thank you for the answer. As you see here, for paternity leave, it's 40% of the absence pay, and for parental leave, it's 10%. And even from this 10%, the social benefits is to be deducted. So frankly, it's for the employee, it's de facto a payless leave, or almost payless. Some good news again, based on the old text of the labor code, the employee could always request payment in cash. And we did met some cases like this, and of course we had some provisions in the work contract that the remuneration is paid via bank transfer, but still it was gray zone. And luckily there's this new provision that the general rule will be bank transfer, because of course those times when all companies had cash desks, I think they are away 20 years ago now. So I remember it was like that when I started working, but that was a long time ago, and I haven't seen any companies which has a cash desk for at least 10, if not 15 years. There are some cases where it is reasonable to pay the employee in cash, and I'm not talking about tax cheating here, of course. I'm talking about the case when the employee's bank account is seized by the court, and any amounts arriving there, or most of the amounts, is taken away by the court. And in this case, it's reasonable for the employee to be paid in cash. Of course, it's your decision if you employ such employees or not, and how you solve it. But in this case, you have to make a written agreement on the way the amount is paid. There are new rules on probationary period in case of fixed-term contracts. It basically says that if the fixed-term contract, it says two things. The first thing it says is that if you renew a fixed-term contract and the job position is the same or very similar to the previous one, then you are not allowed to have a new probationary period. That's the first thing. The second rule is saying that if the fixed term contract is for less than 1 year, then the length of the probationary period should be in line with the length of the fixed term contract. Let me give you an example. If it's a 6 months fixed term contract, then since the maximum length of probationary period is 3 months based on Hungarian law, then in case of 6 months fixed term contract, it cannot exceed 1.5 months. Of course, I'm not talking here that, which is nothing new here, that probably it's not a good idea to employ continuous fixed term contracts. This might be deemed by the courts as unlawful very easily. Some companies are doing this still, but I don't advise you to do so. Another, I think, important change will be that disabled people will not be deemed as pensioners anymore. And it means that if you, for example, want to terminate such a person, you have to give a reasoning. Even though they are called pensioners in Hungarian, so disabled pensioners, remember that from a labor law point of view, they will not be deemed as pensioner. And now we are at the point, I have 3 or 4 slides more, when I want to talk about some novelties which are not related to the modification of the labor code, but I'd like to ask you if you have any questions with respect to the labor code. Okay, then let's go on. Again, this topic of the decision of the Constitutional Court. So what happened is that reading the decision of the Constitutional Court, trade union, I think it's very easy to find out which trade union, went to the court representing its employees and requesting for overtime money, because it claimed that this company, which is written here, is not in line with the provisions of the Constitutional Court. It does not give out daily rest together after the weekly rest, as the Constitutional Court requested. And this court case is still going on, but the judge in Miskolc, he turned to the European Court of Justice and raised questions. The European Court of Justice has not decided yet, but what we have is the opinion of the Advocate General, and based on what we usually see, it's 95% the same as the final decision of the court. So I'm almost sure that the court decision will be pretty similar to what is written in the opinion of the Advocate General. So we can talk about this. What does the Advocate General says? Answering the question of the Hungarian judge whether based on European Union law, daily rest and weekly rest should be given out separately, the Advocate General answered yes. So he answered in the same way as the Hungarian Constitutional Court answered. And why am I saying that what the Hungarian legislators tries to come up with, that if you give out a weekly rest you don't have to give out a daily rest, would be a good solution? Because in this opinion, the Advocate General says that you have to give out both. Either you have to give out the daily rest either before, during, or after the weekly rest. Of course, during means that the 24 hours weekly rest is included in the working time directive will be given out in 2 parts. But the Advocate General says that both has to be given out separately. So I think it's pretty bad news, and it shows that what the Hungarian legislator tries to do will not solve the problem, because at one nice day, the European Court of Justice will say that you just have to give out the daily rest together. I mean, before or after, or even during or between the weekly rest. But as I said, we have to live with this text of law for a few years. And again, I think the only good solution would be what I told you, but the Hungarian legislator did not choose this one. That's the bad news. I also have some good news here, because the Advocate General said that he sees that the length of the daily rest period and the weekly rest period together in Hungary are well over 40 hours. Sorry, I have to repeat this sentence, that the length of the weekly rest period in Hungary is well over 40 hours, which means that although it's only a weekly rest period, its length is more than what the European Union law requires, which is that the two rest periods, daily rest period and weekly rest period together, is 35 hours. So he sees that this 44 hours, let's say, or 48 hours is longer than what the European Union requests. And the Advocate General said that it's up to the Hungarian judge to decide whether, looking at this fact, the Hungarian law is in line with European Union law. So this is, so what happened here is that the Advocate General gave an opinion which is generally very bad for Hungarian employers, but it also gave a little hope. And now all eyes should be looking at this judge in Miskolc, whether he will say that the Hungarian law is in line with European Union law or not. We'll see what this judge is going to say, and if his decision is favorable for the employer, then we can have a little rest, because then I think the problem will be solved for a few years. If not, then practically all Hungarian employers will be in trouble, everybody who has employees. I hope the legislator will find a solution for all these issues sooner or later. I think I talked about this. Now, an evergreen topic, or maybe it was not so evergreen in the past years, because the economy was running so well, but now when the economy has issues, it came up again. The law says, the Labor Code says, that remuneration shall be determined and paid in Hungarian forints. Of course, unless working abroad, it's a different topic, but let's talk about people working in Hungary. The general and the overwhelming interpretation of this rule is that any provisions which mentions euro in a work contract is unlawful, and you can only operate with Hungarian forints. And I was surprised when I had a look at that almost everyone who wrote an article and these are on the same opinion, that you just have to pay in forints, have to determine in forints, and so on. However, there are quite some solutions where the logic is that you de facto agree in euros, but you include a method in the work contract on the basis of which it somehow should be calculated into Hungarian forints. Let's say the amount is in euros, but on this and these days rate, it should be calculated into forints and then paid in forints. In my personal opinion, this is in line with the law because at the end we determine in forint and pay in forint. But I have the minority opinion here. So be aware that any such provisions which does not clearly count in forint might be challenged by trade unions, courts, whatever. And although I have not found any court decisions on this, all the labor law literature are basically on this opinion. We'll see. So there's no court decision on this. At least I'm not aware of any such court decision. But I think it's a bit shocking that most of the labor lawyers are so strict on this issue. Although I have to tell you that I also have some understanding on this, which is not a legal argument, but an economic argument that, of course, it's a national interest that the employees are paid in Hungarian forints because then the government can decrease the value of Hungarian forints more easily than if a larger group of workers would be paid in euros. So this is a hot topic. There's no court decision on this. Most of the labor lawyers say that you have to do everything in forints, agree in forints, pay in forints. But there's also a minority opinion which is saying that if you have a calculation method, it might be okay. But again, I wouldn't bet that this will be the court's decision if there will be a court case from this. We'll see what is going to happen if this comes up at courts one day. And then the last topic I wanted to talk about is telework from abroad. I see it at companies that sometimes they allow this, sometimes they do not even know that the worker went abroad, and they just find out that the worker is writing his or her emails from Uruguay, or I don't know, from South Africa or wherever. And I want to warn you that although there are, it seems to be quite a common practice now, and I even met ads of companies which are saying that, oh, we can get you a teleworker from any countries of the world, and don't worry about administration, we will take care of this. I see quite some risks here. So there are two scenarios: either you are the employer or you hire a company which gets you the teleworkers. Let's talk about the first scenario. The issue here is that if you have a worker who does not work from Hungary but from abroad, it means that partly or even fully the law of that country where the worker is working from might apply. And if the worker works from that country on a permanent basis, then based on the rules of conflicts of law, or international private law, as continental laws call it, has a general rule that the place of habitual work will apply for the work contract, which means that even if this worker is on the other side of the Danube, let's say in Sturovo Parka in Slovakia, and he can see the Esztergom Basilica from his window. Even in this case, he's working in another country in Slovakia. And if he's permanently working from there, then Slovak labor law will apply to this. If this is not the case, because this person is working partly from Hungary and partly from Slovakia, still other provisions, for example, posting provisions, not necessary, but they might come up, or other provisions of Slovak law might come up. Maybe there are provisions in Slovak law which says that even though it's not posting, the Slovak minimum wage has to be paid, or this and this has to be done by the employer. And we are not finished yet, because we only talked about labor law. But there are tax law issues, there are social security issues, which countries' tax laws to be applied, which countries' social security law to be applied. And there are even other issues you don't even think of, like what if there's a provision in the Slovak law that an employer has to report employees working in Slovakia? What if there's a provision in Slovak law that you have to pay some tax, like a local tax, whatever, if you have an employee in Slovakia? And we still talk about a neighboring European law country. But if you go further, let's not go too far. Let's go just to Serbia, let's say. Again, on the other side of the border, what if Serbian law requires a work permit for workers working there for foreign companies? And then we still talk about our neighbors. We still talk about European countries where it's relatively easy to consult a lawyer with. But then what if this country is Bissau Guinea, or what if this country is Uruguay, whatever, a faraway country you have no information on, you don't know nothing about that country, you don't know nothing about the legal system of that country. And this is my first and most important worry here, just to allow the employees to work from anywhere without consulting a lawyer from that country. You might take up risk you don't even dream about. You might, for example, what I was shocked with, if in Spain you breach the posting rules, even administrative rules, like you don't report a worker to the Spanish authorities, you will pay a fine based on the information I have of 175,000 euros per employee. So these are crazy numbers, and you just cannot be sure whether you are in line with all the local laws if you haven't even consulted with the lawyer. So my first and most important advice is, do not allow telework from abroad unless you know all the legal consequences of that in that particular country. And I think those companies who do not act like this are very brave ones, because you just simply cannot know what will be the consequence of this. And I received the questions in connection with this. Okay, how can you find out that the worker is working from home? Well, anyhow, what if the worker gets an accident? What if he tells this at the pub? And so on and so on. So it can be found out very easily by the local authorities, and then your company might get into trouble. And you are not even aware of this risk. And the second scenario is that you employ a company which says, oh, I will do everything. Don't worry about all these local rules. I will take care of everything. First, how do you know they are telling the truth? Of course, you have to have a contract which deals with this very well, but still there's a risk here. Secondly, even if they are extreme professionals, they know all the legal rules in all 200 countries of the world, this might qualify as an unlawful contract for temporary work based on Hungarian law, because they probably will not have permission from Hungarian authorities to provide temporary work service, and probably they also will not have such a permission from other EU countries. So also there are quite a lot of risks you don't think about, and I think even this scenario should be looked at very thoroughly by local lawyers, by host country lawyers, if everything is fine. And I think this is what I wanted to talk about. I see one of you has a question. I'm listening.
Just regarding this working from abroad thing, that is there a maximum of days that we can allow to the colleagues to work? I mean, 30 days or less than 30 days, or if I think 2 or 3, if they work more than 2 or 3 days from abroad, all of these legal restrictions are needed to be used.
Yes, I think the sincere answer is that you cannot know, because you cannot know what are the provisions in those countries you send them or they want to work at. Let me tell you one example. I was just shocked when I found out that Germany requests anyone who is going there on a basis of a work contract to have to be reported ahead. Nobody is doing this, and even if you go to a conference, in theory you have to report this to you should have report this to the German authorities. So I don't know details, because of course I'm not a German lawyer. I just heard this on a conference that this is the case, but really there can be really crazy provisions in all these countries. So if you want to be on the safe side, I would say that even for 1 day or 5 minutes, if you send the worker abroad, you should always consult a local lawyer first.
Thank you.
I don't know if there are any more questions. Okay, those of you who are shy, you can write me on this email.